You know, friends, it's looking more and more likely that come September 18th, Donald Trump might actually be sentenced in his New York criminal case on his 34 felony convictions. Let's talk about that, because justice matters. Hey all, Glenn Kirshner here. So friends, as you already well know, the Supreme Court issued a ruling that essentially U.S. presidents are above the law. They can commit all the crimes they want against the people of the United States, and they are essentially immune from prosecution, immune from being held criminally accountable for their crimes. But the Supreme Court left a little crack of accountability daylight. In their ruling, they said, well, if the crimes that are committed by the president, the conduct that a president engages in that violates our nation's laws, if it involves private conduct, non-official presidential conduct, then a president can be prosecuted. Well, not surprisingly, after the Supreme Court issued that ruling, Donald Trump's lawyers beat feet to court in New York, where Donald Trump was convicted of 34 felony counts, and they filed a motion saying everything Donald Trump did in connection with those crimes in New York. You remember the ones involving Donald Trump making hush money payments to a porn star and then criminally falsifying business records to cover up the true nature of those payments. Why? Because he wanted to steal the 2016 presidential election. Yeah, those crimes. Donald Trump's lawyers filed a motion saying it was all official presidential conduct. Therefore, they urged the presiding judge, Juan Merchan, to throw out the case in its entirety. Well, friends, now the prosecutors have responded with their opposition to Donald Trump's motion to try to toss out his 34 felony convictions. And what they did is the prosecutors looked at that little crack of daylight that the Supreme Court left open, and they kicked the door wide open. They argued that what Donald Trump did was not official presidential conduct. Indeed, most of his criminal conduct occurred before he was elected, before he was sworn in. Oh, and the few things that he did after he was sworn in as president, that ain't official presidential conduct either. His continued attempts to cover up the true nature of his hush money payments. None of it was official governmental conduct. And in a nearly 70-page motion that the prosecutors just filed, they urged Judge Juan Merchan to reject Donald Trump's claim and proceed to sentencing. Let's start with the new reporting. Headline in the Washington Post: New York prosecutors file opposition to reversing Trump's conviction. And that article begins, Donald Trump's conviction for falsifying business records should not be reversed because of the Supreme Court's recent ruling on presidential immunity, for reasons including a wealth of incriminating evidence, prosecutors said in a court filing made public Thursday. Manhattan District Attorney Alvin Bragg's office wrote that the Supreme Court's decision assigning presidents broad immunity for actions involving formal duties does not have any bearing on the May jury verdict that found Trump guilty on 34 felony counts for illegally trying to conceal the nature of a hush money payment to an adult film actress shortly before the 2016 election. Trump's lawyers have argued that jurors were improperly exposed to witness testimony and records that were generated in 2017, in his first year in office, that were extensions of the former president's official duties. Prosecutors said the nation's highest court did not hand down anything that should disturb the verdict or result in a dismissal of the case. Quote, "The Supreme Court's recent ruling thus has nothing to say about defendants' convictions," lawyers for Bragg's office wrote. But even if that decision required the exclusion of all of the evidence that defendant cites here, in other words, the evidence that Donald Trump did certain things after he was sworn in as president, even if that decision required the exclusion of all of that evidence, there would still be no basis for disturbing the verdict because of the other overwhelming evidence of defendant's guilt. New York Supreme Court Justice Juan Merchan delayed Trump's sentencing more than 2 months until September 18 to give defense lawyers time to formally argue that evidence used by Bragg's trial team was not admissible under the immunity doctrine, which prohibits prosecution based on a president's official acts. The U.S. Supreme Court issued its controversial ruling July 1st. The court ruled 6-3 along ideological lines that a president can't face prosecution for official acts or through the use of evidence related to official conduct. Private conduct is not covered by that protection. So friends, let's break it down. Let's translate it all from legalese to English. First of all, Donald Trump's convictions should not be thrown out because everything he did involved private conduct, not official presidential conduct, regardless of when he did it. Whether he did it before he was elected and sworn in, which means it couldn't be presidential conduct, official conduct. He wasn't president. And those things that he did after he was sworn in, those things that were introduced as incriminating evidence against him at trial, that wasn't official presidential conduct either. That was the ongoing attempt to cover up the true nature of the hush money payments. This was all private conduct, not presidential official conduct. Therefore, none of what the Supreme Court said in its recent horrific unconstitutional ruling that a president is above the law, nothing the Supreme Court said in that opinion undermines Donald Trump's convictions in New York, and therefore Judge Merchan should proceed to sentencing on September 18th. Now, let's shift to a secondary question. Let's assume that Judge Merchan says, well, some of it may have been close enough to official presidential conduct after he was elected. Some of these additional acts he undertook, that maybe those few things should not have come into evidence. That's fine. Then we need to talk about the legal doctrine of harmless error. Stay with me here for a minute, friends. This is going to feel like a Team Justice Law School class, but I promise it will be a short one. In virtually every criminal trial that is tried in this country, everyone, including everyone that I tried in my 30 years as a prosecutor, guess what? Mistakes are made. Criminal trials are human endeavors, right? Mistakes are made by prosecutors, by defense attorneys, by judges. And if every single mistake that was made during the course of the trial required a new trial, required an appellate court to reverse a conviction and send it back to the trial court for a new trial because a mistake was made, well, then that rule would sort of swallow up the entirety of the criminal justice system. No cases could ever make it through the appeals process. We would forever be on a hamster wheel trying cases over and over and over again. That is why the law recognizes the doctrine of harmless error. Harmless error stands for the following proposition. Mistakes are made in trial all the time. For example, maybe a witness testifies to something that was really hearsay, So the rules of evidence should have prohibited that piece of testimony from being admitted by the judge and being considered by the jury. But all of the other evidence in the case, which when it comes to Donald Trump's case was mountainous and overwhelming and incontrovertible, supports the conviction, notwithstanding that piece of hearsay that should not have been considered by the jury. Therefore, harmless error dictates that the conviction will be affirmed on appeal. I don't believe any of what Donald Trump did was official governmental presidential conduct. No way. But if some of it was, its admission was harmless. Therefore, the charges will not be thrown out, in my opinion. Judge Merchan will proceed to sentencing, in my opinion. We'll know soon enough. He's going to rule on that motion in the coming weeks. And then on September 28th, we will all eagerly await Judge Merchan's decision regarding Donald Trump's sentence for his 34 felony convictions for conduct that was designed to deprive the American voters of the full value of our vote by covering up and lying about and ginning up false business records to mask the true nature of those hush money payments. And when Judge Merchan issues the sentence, I believe, and we're going to talk more about this in the coming days and weeks, I believe it will include a period of incarceration for Donald Trump. Because justice matters. Friends, as always, please stay safe, please stay tuned, and I look forward to talking with you all again tomorrow.